reasonableness of disability adjustments, and that schools are obligated to provide disability adjustments except for the case of unjustifiable hardship.
Yep.
And even though they know that and we know that, we still hear as parents very often on the Sunshine Coast, well, we just can't provide that because of resources.
Yep.
So what do we as parents say when we're refused disability adjustments just straight out? What would you advise a parent to say to them?
Okay. Thanks. There's a few strategies. I guess the first is to assess as a parent whether you think that saying no is a reasonable call for the school to make, or whether, given the nature of the school, given the capacity of the Department of Education, the size of the budget, the needs of other kids, whether or not in fact they ought to be able to stretch the resources further. Because at some point, there's always going to be a tension between the parents who, and I'm a parent, so I get this, the parents who are going to want the absolute best for their child at school, and so that's why parents are such good advocates, and the school who has to weigh up the needs of all of the kids who are attending the school. So you've got to think through and assess the school's decision. And often the way to do that is exactly what you guys are doing, which is to put together a group like this, which allows comparisons and discussions to take place where other parents might say to you, well, yeah, look, it's good that you've got this. You're probably going to struggle to get the next thing that you want. Sure, that would be ideal, but do we always get ideal? No, we probably don't. So then you've got to say, all right, if my judgment, having weighed all those opinions and thought the thing through, is that in fact the school ought to provide that for my child. In other words, in order for my child to get that equality in education, it ought to be provided. Then do you go the next step? Do you look at lodging a discrimination complaint? And again, it's really useful to have advocates and support people and build around you a circle of people who will support you in that complaint. And if there are kids with similar disabilities at the same school or at schools nearby, maybe it's best, rather than lodging one complaint, to lodge 6 complaints about similar issues and run them as a group of complaints. So not necessarily what's called a representative complaint, which is a bit like a class action, but run them as 6 individual complaints. The problem with representative complaints, and I'm not saying you shouldn't lodge them, but the downside of representative complaints is that individual damages or compensation can't be awarded from representative complaints. Now, you might say to me, oh, that's all right, I don't want money out of this, I just want my child to get more resources. But the situation is that when you lodge a representative complaint, the respondent to that complaint, so the school or the education department, knows that damages can't be awarded. So immediately it's a weaker complaint, right? Because they know that there's no way they can be required to pay out money in compensation. Even if they lose, they're only going to have to pay out the money to provide the resources that you're seeking. So if you choose to go down the track of lodging a representative complaint, and you can do it, if there's a particular issue which relates to a class of people with disabilities, you always lodge individual complaints as well, so that you've removed that, or you've strengthened those complaints rather than having it just a representative complaint. And so you have the discussion about whether or not the resources are going to be granted, and you have it around a conciliation table rather than just across the principal's desk, which gives it more weight and more importance. And you can work with the other people in the group or work with your advocates to pursue that complaint. All of these things, there's no right or wrong answer. They're all judgment calls. But what I'm trying to do, I suppose, is give you strategies to address them. And if it's, you haven't been able to achieve conciliation, and I should say that more than 50% of our complaints are conciliated, So the odds are 1 in 2 that you'll be able to resolve the complaint by conciliation, and you still want to pursue the matter, then there is the option of going to the federal court. And I'm happy to talk about the pros and cons of that. But so, you know, that's, if your judgment is that the resources that you're being offered are not adequate and that your child should have more resources, then that's a course of action that's available to